I didn't read Section 3, accomplice liability of the BARBRI outline for criminal law, starting on page 17. Parties to a crime, A, Section A, starts with 1, common law. The common law distinguished 4 types of parties to a felony. That's principals in the first degree, persons who actually engaged in the act or omission that constitutes the criminal offense, principals in the second degree, persons who aid, command, or encourage the principal and are present at the crime, accessories before the fact, persons who aid, abet, or encourage the principal but are not present at the crime, and accessories after the fact, persons who assist the principal after the crime. Now, A, the significance of common law distinctions. At common law, the distinctions between the parties had a great deal of procedural significance. For example, an accessory could not be convicted unless the principal had already been convicted, although both could be convicted in a joint trial if the jury if the jury determined the principal's guilt first. Most modern jurisdictions have abandoned this requirement, and an accessory can be convicted even if the principal has evaded apprehension or has been tried and acquitted. 2. Modern statutes. Most jurisdictions have abolished the distinctions between principals in the first degree, principals in the second degree, and accessories before the fact. Accessories after the fact are still treated separately. Under the modern approach, all parties to the crime can be found guilty of the criminal offense. For convenience, this section will designate the actual perpetrator of the criminal act as the principal and the other parties to the crime as accomplices. A, principal, B, accomplice, C, accessory after the fact, before we move into mental state. Principal. A principal is one who, with the requisite mental state, actually engages in the act or omission that causes the criminal result. Also, anyone who acts through an innocent, irresponsible, or unwilling agent is classified as a principal. So, for example, A gives a poisonous drink to B to give to C. B does so. C drinks it and dies. If B did not know that the drink was poisonous, or if B was mentally ill or under duress, A, not B, is the principal. Note that the principal need not be present when the harm results. B, accomplice. An accomplice is one who, Romanet 1, with the intent to assist the principal and the intent that the principal commit the crime, Romanet 2, actually aids, counsels, or encourages the principal before or during the commission of the crime. C, accessory after the fact. An accessory after the fact is one who receives, relieves, comforts, or assists another knowing that he has committed a felony in order to help the felon escape arrest, trial, or conviction. The crime committed by the principal must be a felony, and it must be completed at the time the aid is rendered. Today, the crime is usually called harboring a fugitive, aiding escape, or obstructing justice. Now, 1. Penalty. Typically, the punishment for this crime bears no relationship to the principal offense. 5 years is the most common maximum sentence. Exemptions are usually provided for close relatives of the principal offender. The common law exempted only the spouse. Mental state, dual intent required. B of this section. What was that? Accomplice liability. In order to be convicted of a substantive crime as an accomplice, the accomplice must have, Romanet 1, the intent to assist the principal in the commission of the crime, and Romanet 2, the intent that the principal commit the substantive offense. When the substantive offense has recklessly or negligence as its mens rea, most jurisdictions would hold that the intent element is satisfied if the accomplice intended, Romanet 1, intended to facilitate the commission of the crime, and Romanet 2 acted with recklessness or negligence, whichever is required by the particular crime. Provision of material. In the absence of a statute, most courts would hold that mere knowledge that a crime would result from the aid provided is insufficient for accomplice liability, at least where the aid involves the sale of ordinary goods at ordinary prices. However, procuring an illegal item or selling at a higher price because of the buyer's purpose may constitute a sufficient stake in the venture for a court to find intent to aid. Example, A tells B that he wants to buy a can of gasoline to burn from B to burn a house down. B sells A the gasoline and A burns a house down. B is not liable as an accomplice to arson unless it was illegal to sell gasoline in cans, or B charged A twice his usual price because of what A was using the gasoline for. Scope of liability. An accomplice is responsible for the crimes he did or counseled, and for any other crimes committed in the course of committing the crime contemplated, as long as the other crimes were probable or foreseeable. Example, A commands B to burn C's house, and B does so. The fire spreads to X's house, and it was foreseeable that it would do so. A is an accomplice to the burning of X's house. 1. Inability to be principal, no bar to liability as accomplice. One who may not be convicted of being a principal may be convicted of being an accomplice. Example, at common law, a woman may not be convicted of rape as a principal, but she may be convicted of that crime as an accomplice. Which I had a question about that the first time I read this, not reading it out loud. My question was, are the 3 people party to this? Because it just would be very hard for one woman to rape one man, and for the charge to be that of an accomplice to rape. But nonetheless, that question is one for the courts. Exclusions from liability 2. Under the scope of liability, C section. Under some circumstances, a person who would otherwise be liable as an accomplice is not subject to conviction, either because of the legislative intent to exempt him or because he has a special defense. Members of a protected class A. If the statute is intended to protect members of a limited class from exploitation or overbearing, members of that class are presumed to be immune from liability, even if they participate in the crime in a manner that would otherwise make them liable. For example, A is charged with transporting B, a woman, in interstate commerce for immoral purposes. B is charged as an accomplice on the ground that she encouraged and assisted A. Is B guilty? Hell, no. The statute was intended to protect women, and thus the woman transported cannot be convicted. So what they're not saying here is that she was in on it, she was okay with it, she didn't mind being transported for the immoral purpose, and that does not make a difference. She's not liable because she's a protected class. So that's how this example makes sense. Now B, necessary parties not provided for. If a statute defines a crime in a complicit, that's the word I was looking for. Okay, if a statute defines a crime in a way that necessarily involves more than one participant and provides for the liability of only one participant, it is presumed that the legislative intent was to immunize the other participant from liability as an accomplice. The rule is most often applied to statutes making the sale of certain items a criminal offense. So A asked B to sell her some heroin. B did so. Both were apprehended. B was charged as a principal for the sale of narcotics. A was charged as an accomplice. Is A subject to the conviction? Hell, no. Since the statute prohibiting sale does not mention the liability of the buyer, the presumed legislative intent is to exempt her. I don't think that means she's exonerated. I think it's one for you would want to look at the actual statute for that, because this is just a hypothetical example. But the buyer, what they're trying to say is the buyer is not an accomplice to the sale of heroin because she didn't sell it. Okay, withdrawal. One who has rendered encouragement or aid to another may avoid liability as an accomplice if he voluntarily withdraws from the crime before it is actually committed by the principal. What is necessary for an effective withdrawal depends upon what the person initially did. If the person merely encouraged the commission of the crime, withdrawal requires that he repudiate this encouragement. If the person assisted by providing some material to the principal, withdrawal requires at least that the person attempt to neutralize this assistance, example, by doing everything possible to retrieve the material provided. If it is impossible to withdraw by these methods, an alternative means of withdrawing is to notify authorities or take some other action to prevent the commission of the offense. In any case, the withdrawal must occur before the chain of events leading to the commission of the crime becomes unstoppable. Example, B expresses a desire to kill C. A encourages him to do so and provides him with a gun. Later, A changes his mind. He seeks B out and tells B that his earlier position was wrong and that B should not kill C. He also gets his gun back. Nevertheless, B obtains another gun and kills C. Is A liable as an accomplice? Hell, no, since he did all that was possible to render his encouragement and assistance ineffective before B's plan to kill C became unstoppable. So that's the end of section 3.